Welcome. Good morning, very good morning to those of you on the West Coast. Also, good morning to those of you on the East Coast, and a big hello to everyone in between. My name is Dan Balkaran, as you see on the screen, and I'm an employment lawyer at Samfiru, Tumarkin, LLP, as always, Canada's leading employee-side employment law firm. Housekeeping note before we get started. If you need to get a hold of us throughout this broadcast or at any time, you can reach us at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay, so please send in your questions. I know we're at a different time this week. Appreciate everyone sending their questions in at this earlier time. But send them in as soon as you can. I'd like to, if I can, get through all of them before the end of the broadcast. Okay, so question from Eric. After I came back from vacation, my employer has reduced my schedule to 0 hours. They're just not scheduling me and have done this so they can avoid firing me and paying severance. What are my options at this point? Well, I mean, listen, if they're not, if you don't have any work, so the core of a contract of employment is that you go to a job to work a certain amount of hours in exchange for a certain amount of pay. If they just stop paying you, you have effectively been terminated. Now, technically, you have been constructively terminated, which means the actions of the employer in ceasing to pay you are a termination of your employment. Do you know, Eric, if they're going to be giving you? You said it's so they can avoid paying you severance. That's not going to work. But do you know if, like, have they said, oh, you're going to get hours in the next week or two? Sometimes when there are cash flow issues, we'll say, with a business, hours can dry, or there's just no work at this particular time. Hours can dry up on a temporary basis, but it's not indicative of a permanent change on the part of the employer. Do you know for sure that this is a permanent thing, that they're not bringing you back and they're just trying to soft pedal you out the door? So I'd answer that question. But no, it's a termination of your employment, Eric. And so if you choose to treat it that way, you've been terminated and you can go after severance. Now, the amount of your severance is a function of what does your employment contract say? You know, there's two types of severance. Well, if you're provincially regulated, which 90 to 95% of us are, there's two types of severance. Small severance, which is statutory, it comes from the Employment Standards Act, roughly 1 week per year of service to a maximum of 8 weeks. Or big severance, which comes from decisions by the courts. It's roughly 1 month of severance per year of service to a maximum of 24 months. So a huge variation in the two, and what determines which one you get is your employment contract. So it depends what's in your employment contract. And then if you get into the big severance, it depends on your age, length of service, position, and how long you're going to be unemployed for. So, Eric, I would talk to an employment lawyer right away, see what kind of claim you have, what value it has, etc. I'd also look into, is the reason why they reduced your hours to 0? Is the employer going out of business? Does it have no money? These are all important questions to ask. But I would talk to an employment lawyer right away. And if you want to talk to us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. All right, let's get into the next one. Okay. Question from Stormy. I work at a remote location, bush camp in BC. The amount of time I am there results in me being paid overtime. My boss is now trying to cut overtime. I am paid and is telling me that I need to take a few days off while I'm at the remote work site. I think I should be paid for any day that I'm on this site. What are the laws for this situation? I mean, the short answer to that question is, at least for me, is I don't know. If you're not working, if your boss is saying, okay, well, so normally you were getting paid for every day you're up at the work site. Now, if that is what's in your employment contract, then that's what you're entitled to. However, if your employment contract doesn't cover, hours that you spend at the camp that you're not working, okay, or doesn't say anything about overtime hours at all, then your entitlement to pay and overtime comes, if you're provincially regulated, which you probably are based on what you're telling me, comes from the Employment Standards Act. And you're entitled then to time and a half for every minute you work over 8 hours in a given shift, double time for every minute you work over, or every hour, I should say, you work over 12 hours in a given day, and time and a half for any hour you work over 40 hours a week. So those are what your entitlements are. You can't get less than that. You can have something called an averaging agreement, which allows you to work longer shifts with no overtime if there's an agreement, and that might be because you want to work 3 12-hour shifts or 3.5 12-hour shifts to it's better for your schedule and you get more days off, et cetera. But absent an averaging agreement, you're entitled to the overtime rates that are in the Employment Standards Act, which are your overtime floor, and also your employment contract might say something different, and provided that it's more than the overtime floor of the Employment Standards Act, that's what your entitlement is. But if it's not covered in your contract and you are given time off, if you are working at a camp, it's remote, you've traveled up there, there's nothing to do up there, and they just say, well, we're giving you 3 days off, do they have to pay you just because you're up there? I mean, I would think the answer is no. You have your time off, unless it's covered in your actual employment contract. So I would take a look at your employment contract, see what it says. But in terms of your entitlement under the Employment Standards Act, I must confess, this particular question I don't know the answer to. My suspicion is that if they give you the time off, you don't have an entitlement and to the overtime. And so the real solution here is an amicable one, or if this is a really important issue to you, do you want to continue working there? So and those are choices everyone can make. They can always choose to go work somewhere else, but in this particular case, I imagine if they say, well, we're going to give you three days off, we're going to have 3 days off up at camp, which I imagine is probably not ideal, but I don't expect that you'd have some sort of entitlement to pay just because you're up at camp but not working. Okay, I'm not going to say who this is because I don't want to identify them. I'm also not going to say, okay, so they're working, I'll just say, for a foreign-based company, but he or she is working in BC. They said we are under a dependent contractor classification, but I think this is for that foreign country. The same rules apply here. Sure, okay. I certainly have no knowledge or insight into employment classification in Germany. I will say that there are the vast majority of worker relationships in the country, or in the province, in this case, you're in BC, and BC are employment relationships where an employee is an employee of the employer. But some of them are structured as contractors. And so employees have a number of rights under employment legislation and in decisions by the courts over a considerable length of time. Independent contractors do not have any rights. And so independent contractors are working for themselves. They pay their own taxes. There aren't any of the same government deductions for CPP and EI from their paychecks. But so you can think of, classically sort of gig workers are considered independent contractors. But the law has looked at independent contractors because they're certainly cheaper for employers to hire, and said, well, just because you classify someone as an independent contractor doesn't mean that they actually are an independent contractor. And it could be they are, in fact, an employee subject to employment protections. Or it could be that they are a contractor, but aren't sufficiently independent to be an independent contractor and are, in fact, a dependent contractor. Now, and for as far as everyone is concerned here, employees have all employee rights and rights attached to their employment relationship with the employer, including upon termination, where they have a right to severance as codified in, if they're provincially regulated, the Employment Standards Act or Code, depending on your jurisdiction, and also within the common law, if applicable. Independent contractors have no such rights upon termination. Independent contractors have common law, big severance, we'll call it, rights upon termination, but not the protections of the Employment Standards Act, which can be crucial to getting around the language in dependent contractor services contracts. Okay, so as far as primarily probably for purposes of termination and what your rights are after termination, if you are in fact a dependent contractor, certainly you're going to want an employment lawyer to look at what you're entitled to upon your termination. If you're a dependent contractor, you won't have a lot of the other rights that employment protections that come with the Employment Standards Act. But if you have a specific question, certainly, if you can send it in before the end of the broadcast, I'll take a look at it. But do we have here classifications of dependent contractor? Yes. They're usually sort of after the fact classifications, after the fact of termination. Really, there's most relationships between company and worker are either employment or at least considered by the company or the worker to be one of employment or one of independent contractor. I've never heard of an employer saying, hey, Mr. Smith, you are a dependent contractor. That's just not something I've ever heard of. But nonetheless, yes, we have dependent contractors here. That's the relation. There's three types of worker relationships: employee, that's most of everybody; dependent contractor; and independent contractor. Okay, I hope I answered your question. I don't. There's no specific question that you asked, but yes, we do have that here. If you let me know if you can get a specific question before the end of the broadcast. Okay. Desiree, how long does it take to settle a constructive dismissal case? Okay, there are a lot of different parts to that particular question. So I'll take the settlement part first. So in employment law, disputes generally arise from termination. So someone has been terminated, either explicitly or constructively, and then there's a dispute over how much money the employer owes the employee arising from that termination. And in those disputes, most cases do settle. Most disputes settle. The vast majority of them settle. Some do not, depending upon the employer's perspective, the fact pattern, what the employee allegedly did, the motives of the employer. So if some employers, their motivation is to let all of their employees know it's going to be a challenging ride to get money out of it. Some, I've seen this quite often, where there are wealthy business owners who just don't want to be wrong or don't want to lose, and they don't care about how much money they spend to defend their claims or claims against them. But the vast majority of them settle. How long depends on how reasonable the parties are willing to be. Some of them settle in a week, and some of them, take quite a bit longer than that. So I can't answer your question with any more specificity than that. Depends on the situation, depends on the case, the allegations, and the employer or the employee's disposition with respect to compromising. I'll tackle the other part of it now. So constructive dismissal. So in many ways, there's no difference between a termination without cause and a constructive dismissal. So termination without cause means the employer has fired you and not done so because there's a valid reason to give you zero at law. Okay, so you didn't punch your boss in the face or come into work high on drugs. They fired you for they're reorganizing the team or something, or cutting costs. So terminate your employment without cause, and they don't pay you enough severance, and then there's dispute over severance in terms of the amount of severance you're entitled to. What a constructive dismissal is that instead of an explicit termination by the employer of the employee's employment, the actions of the employer are in effect a termination. And so the best way I can illustrate what I'm saying is through an example. There's two ways to get there through the actions of the employer. One is that the employer changes a fundamental term of the employee's employment that the employee rejects. And two is that the employer effectively repudiates the employee's employment by indicating through its actions that it doesn't want to be the employer of the employee anymore. The first one is a lot easier, and I'll just give you an example. Let's just say your work cuts your pay by 35%. That's a termination of your employment. That's not what you signed up for. Okay, so constructive dismissal, fairly straightforward. It gets a little more complicated if there's a demotion but no change in pay. So if your employer, you were a CFO and now you're in the mailroom, or you're the janitor or something a lot different, that's a constructive termination of your employment. The complicating factor with constructive dismissals is that a judge has to agree that the actions of the employer are a constructive dismissal. If you pass that first test, then you get into the evaluation of how much severance did the employer pay you? Was it enough? How much does the employer still owe you, et cetera? But if you fail that first test, you actually weren't constructively dismissed, you have quit and you get zero. Okay, so it's an all or nothing threshold question at the start of any sort of severance claim. And the core of it is, were you actually terminated? Would a reasonable person in your position be able to continue working in your job? Okay, so to give a very loud message here to everybody, which is, or warning, I will say, constructive dismissals are hard. They're too hard to handle on your own. No one should do it. No one should trigger a constructive dismissal or allege constructive dismissal without legal advice first and without ongoing guidance from a lawyer. They're too complicated to do on your own. Okay, so if you need to, Desiree, if you need to reach us, you can do so. Help at employmentlawyer.ca, and 1-855-821-5900. But that's the difference between constructive dismissal and a regular dismissal. Ultimately, there's no difference. If a court considers you to have been constructively dismissed, then you are dismissed, and a termination and a constructive dismissal are the same thing. It's just you have to get to the point of a classification of constructive dismissal. Now, not to scare anyone with the word a judge or court, again, most of these things settle. It's just that if they don't, that's what happens. That's who decides whether or not you've been constructively dismissed, and you have to pass that threshold question of if the employer actually constructively terminated your employment. Okay, Ron asks, can an employer change you to being an independent contractor after you've been a salaried employee for several years? Well, it's a really interesting question, Ron. So whether or not you're an independent contractor, and the person who asked about the dependent contractor situation earlier, and I didn't fully answer that question. So whether or not you are truly an independent contractor, merely a dependent contractor, or an employee is a function of the relationship between the parties. So for example, are you getting paid a regular paycheck that doesn't have variable income? Probably an employee or a dependent contractor. Whose business are you in business for you or actually for the employer? Whose tools do you use? How long have you been there for? Are you representing yourself as an employee of the company? There's all these different factors that go into and it's a case-by-case analysis of what you are. So if they shift you to becoming an independent contractor and you lose your job, it may be that you're still an employee. And if there's no change, Ron, whatsoever between your duty set and your job as an employee and then as an independent contractor, chances are when your termination comes, if it comes, down the road, you'll be able to argue that you're still an employee and go after, full freight employment severance. However, that's not your question. The question you asked is, can the employer just do it? Well, I mean, with all things, if you say no to it, they're either gonna do it anyway, or they're gonna fire you. I mean, or I guess option 3 is they'll just leave you in your employment position. But I'm not. I don't expect that to be the case. So, you'll have to look at it and how far do you want to push back on it. If there's an amicable solution that you can reach, why is it they're doing it? I expect because they want to save money. But it's not exactly clear why they're doing it. Maybe Ron, find out why they're doing it. But can they just impose it on you? They could. The question is that a termination of your employment? A constructive termination of your employment. I mean, arguably, you lose all these rights. I haven't ever had a case like that, but I could make the argument with a straight face that it is a constructive dismissal of your employment to lose all your employment rights. So, or potentially lose all your employment rights. So you could, if you want to get out from your job with some money, potentially, I'm not guaranteeing anything, but the possibility of getting money on the way out, depending on what your employment contract says and your age, length of service, and position, you may wish to talk to us or talk to an employment lawyer, or if you want to talk to us, you can do so. Employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Just take a look at it and see if we think it's a constructive dismissal. If this is imposed on you, I don't know if it has been or not. But if you reject it, they could fire you. So just be aware of that. But that also might be what you want, right? Because if you're trying to get out with severance. So I would talk to an employment lawyer first, find out what your legal position is with respect to a potential termination. Do you have a windfall of money coming to you potentially, or, do you have very little coming to you, in which case that you can assess your options about how you want to handle this change to an independent contractor after you're in possession of information about the numbers. Okay, we got a few more questions left. Not very much time, so I'll try to race through these. Martha asks, I worked at the same telecommunications company for 10 years. Under what circumstances can an employer enforce voluntary resignation for not accepting a new position? Well, they can't enforce voluntary resignation ever. No company can do that. That's a termination of your employment. So if they say, I'm a little unclear, they want to promote you or change you or demote you or move you in a different role, you say no, well, their option is to fire you, right? So, but can they enforce? No. Enforce a voluntary resignation is a termination. If you do not agree to a voluntary resignation, do not sign anything, talk to an employment lawyer right away. I don't want you to sign away your severance rights. So Martha, I'll give all the contact information at the end for us, but talk to an employment lawyer right away. There's no such thing as an enforced voluntary resignation. That's you quitting to save your company money, most likely. So really what that is a termination of your employment. Okay, Joey asks, working for a nonprofit, and they're saying the number of us aren't considered full-time permanent. So are we owed no severance if let go? Is this true? No. I mean, you're owed. It's just because you're not full-time permanent doesn't mean you're not owed severance. There's no distinction about permanency or not under the law. It's really just a function of what does your employment contract say? And then if you can get around your employment contract, your age, length of service, and position, Joey, you should talk to an employment lawyer. I'll put our contact information on the screen at the very end. Okay. Nasser asks, I was terminated for no cause while I was under accommodation for over 2 years for a work injury. Now I have a permanent impairment. What are my rights and how many months severance? You only got 4 weeks severance. Okay, so Nasser, you were under an accommodation. So the question is, were you working or were you on a medical leave for 2 years? If you're on a medical leave for 2 years and your injury is permanent, such that there's no possibility of returning to your work, your employment is likely frustrated and your company owes you zero. Okay. Medically frustrated. That just means that your injury has dissolved your contract of employment and they don't owe you anything, and there's just no possibility of the contract being fulfilled. However, if you were working with accommodations and then they decided to terminate you because once they found out you're going to need permanent accommodations, it's very possible that you have a severance case. You should talk to an employment lawyer right away, but it's a hard severance case because the employer is going to say that whatever the nature of your injury was, let's just say it was your back and your job required you to lift 60 pounds and now you can only lift 20 pounds. They could plausibly argue that your medical injury prevents you from doing the core functions of your job, and therefore your employment has been medically frustrated. But working against them there is the fact that you've been doing the job with accommodations for 2 years. So those are hard cases, but you can't do that on your own. If that's the case, you need to talk to an employment lawyer. I'll put the information on the screen when we're done. I'm sorry. Okay. Yeah, I think we can get through this. Okay. Rose, I think, if I understand correctly, you are a member of a union, so I'm not going to be able to answer your question. And I direct you to either union counsel or your union representative. Okay. Sherry asks, I was recently put, and just sorry, Rose, it's because I don't do any sort of union work, and I don't think anybody at our firm does actually. So Sherry asks, I was recently put on an unfair performance improvement plan. Human resources revoked it almost immediately upon challenge after I claimed it was retaliation for turning down a significant change to my job. Was this a protected activity? I don't know what this refers to. Retaliation is a problem, but unless it's retaliation for a complaint about health and safety or infringement of a human rights protected ground, it doesn't really get you anywhere. So they said they wanted to change part of your job, you said no, and then they put you on a performance improvement plan. Well, I mean, if it's not a fundamental change to your employment, if it is a fundamental change to your employment and they impose it on you, it's a constructive dismissal. But you run the risk if your employer says, hey, your territory was BC and now we want to include Alberta in your sales territory, and you say no, well, they might fire you, right? So, but they can only do so with severance. But that is a risk that you take. So, it doesn't look good for the company that they appear to have retaliated against you. But that doesn't play a role in your legal rights because it was just for a job change. So listen, when you get put on a performance improvement plan, generally it means that you're not going to be working at the employer very much longer. The employer wants you out and is trying to paper the ground so that it can let you go for less money for potentially just cause. Okay, so if the PIP was revoked, that might be different, but your situation is in dire straits there if they're giving you a performance improvement plan and you rejected a request to do, as you said, new skills, new certifications for a new job. So I would look at that very carefully, Sherry. You may wish to either try to mend fences with them if you want to stay there, and have some sort of amicable resolution, or if not, you may wish, because I generally when performance improvement plans are issued, at some point the employer is going to get rid of the employee, you may want to start looking around for a new job. Okay, those are just my thoughts on that. But I don't really understand your question beyond that. But I think that you want to take a long look at what's happening there and how long you're going to be able to continue working there. Okay, we're done. Martha's back. My telecom company, they offered me an alternative position that I don't want to accept, being there for 10 years. Do they definitely owe me severance? Well, it depends what they do, right? If they impose the change on you and it's a fundamental change, then you have a constructive dismissal. If it isn't, then you've got to keep working in the position. Or if they terminate you, you might also have severance. But you need to talk to an employment lawyer because you need to know how much severance you potentially have coming to you. So if you need to get a hold of us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Thanks all. Great questions. And join us next week on Monday, September 23rd with Chris Justice. He will be answering all your questions, employment law. I'll be back in 2 weeks at my regular time slot of 10:30 a.m. Pacific time. Have a safe and wonderful weekend, everybody.